If you do that, you have done perhaps the absolute worst thing that you could do in the bankruptcy context. What you just described there is what's known as a fraudulent transfer. A fraudulent transfer law has been around since ancient Rome. No, I'm not kidding. Really ancient Rome, the days of Julius Caesar. So we've got a couple of thousand years worth of well-developed law on this matter. And so the law has become very sophisticated, and you will not win. So in the United States, we have two working definitions of a fraudulent transfer. There are some sub-definitions, but these are the two main working definitions. The first captures the ancient Roman idea. A transfer is fraudulent with respect to a creditor if it's done with the intent to hinder, delay, or defraud the creditor. So if you start transferring stuff because you've got these creditors, you're seeking to hinder, delay, or defraud the creditors. But there is a problem with the definition, and it's in the word intent. Since we don't know what another person intends, the law has a second definition. And here the definition is a transfer is fraudulent with respect to a creditor if it's done without getting a reasonably equivalent value in exchange for the transfer. Outside of bankruptcy, if you do a fraudulent transfer, the creditor can undo that transfer. The word we use is avoid. It's a somewhat unusual usage of the word avoid. It means to render null and void. So the creditor can avoid the transfer to the extent necessary to pay the antecedent debt. If you file for bankruptcy protection, the trustee assigned to your case steps into the shoes of the creditor and inherits the creditor's right to avoid the transfer, but the trustee can avoid the entire transfer because the trustee is doing it not just on behalf of that one creditor, but on behalf of the entire creditor body. On top of that, if you do a fraudulent transfer during the 1 year prior to filing the bankruptcy petition, you are rendered ineligible to get a Chapter 7 bankruptcy discharge. And so if your goal is to get a Chapter 7 discharge and you've done the fraudulent transfer, you're going to be in really hot water there. You're not going to get the discharge. So that's a very bad move. In fact, it couldn't be worse. And the look-back period on fraudulent transfers, that is, if the trustee wants to undo the transfer, depends on the statute that the trustee appeals to. The bankruptcy code has a fraudulent transfer avoidance statute that looks from the day we file the petition, and the trustee can avoid fraudulent transfers during the 2-year pre-petition period. But the bankruptcy code permits the trustee to piggyback on non-bankruptcy law. So the trustee can use the California statute, which has a 4-year look-back period, but that's measured from the day the trustee files the complaint to do the avoidance action. And there is additional time if the transfer couldn't have been readily discovered. And then if you have the IRS as a creditor, then the trustee can use the IRS's statute of limitations, which is a 10-year look-back period. So you won't get away with this. And these trustees are really quite enterprising. The investigative tools they have are really quite impressive. They uncover things that you wouldn't think they would have been able to uncover. So you do want to be very careful about that. And my final comment on this, as far as investigation is, associated with most bankruptcy cases are two trustees. In a standard Chapter 11, there isn't a chapter trustee, but generally there's a chapter trustee and the U.S. trustee. So, for example, if you do a Chapter 7, the court will appoint a Chapter 7 trustee to your case, and then there's the Office of the U.S. trustee that sort of superintends all bankruptcy cases. The U.S. Trustee's Office is a subdivision of the U.S. Department of Justice, and the people there are tasked with policing the integrity of the system. And they do take their role very seriously, and one of the investigative tools they have is the FBI. And so if you think you're going to get away with some sort of malfeasance, such as a fraudulent transfer, be aware that the FBI has investigative tools that are going to find you out. So you really want to be honest in all this. Don't start conveying assets especially not to family members and friends, because if your family member decides to try to defend against the avoidance action by saying, well, I got a reasonably equivalent value in exchange for the transfer, The presumption generally when it's an insider who's the recipient is that you didn't get a reasonably equivalent value in exchange for the transfer. Long and short, don't start transferring assets prior to filing the petition. And so if you've got assets that we can't exempt, and you can watch some of the videos on exemption, then you might consider doing a chapter other than Chapter 7, where you can still keep the assets, though you will end up making payments through a plan of reorganization.